Okay, guys, I'm picking this up with BPD's overly aggressive tactics on page 78. I'm going to do about an hour's worth of video here, so I'm hoping that I can get into approximately page 115 or so. For example, in a 2014 incident, an officer informed the young man, Matthew, that he could not smoke inside a public market and asked him to leave. Matthew left and the officer followed him outside. Once outside, the officer asked him for identification to issue a civil citation. According to the department's use of force report, the Matthew became agitated and started to argue with the officer, attracting a crowd. The young man refused to provide identification and moved backwards. The officer grabbed the young man by his jacket, at which point he pulled away and fled. Two officers pursued Matthew for blocks, and when they eventually caught up with him, used arrest and control techniques to tackle him and to stop him from further fleeing. While trying to control him on the ground and place him in handcuffs, he sustained abrasions to the left and right side of his face and a cut to his lower lip, requiring 2 stitches. The officer arrested Matthew for being disorderly, but according to the arrest database that BPD provided, the state's attorney's office declined to formally charge the young man. The officer repeatedly escalated this encounter using unnecessarily aggressive tactics against a young man who had not committed a crime, resulting in the man being subjected to excessive force. The decision to grab the man by his jacket after he had obeyed the officer's warning by leaving the market escalated the encounter and led to the man resisting the officer's force by pulling away. The officer's decision to then pursue the young man for a mere civil citation also escalated the encounter. Other than calling off the pursuit, which would have been appropriate, as discussed in more detail on page 91, the most likely way to end the pursuit was by using force. Tackling and using control and arrest techniques resulting in 2 stitches and abrasions to his face was disproportionate in light of the civil violation the young man had committed and where he posed no threat to officers or anyone else. In another example, in a 2010 incident, a major who was patrolling in uniform in an unmarked police vehicle observed several people on the steps of an apartment building. He asked the group if everyone lived there. One of the group, a young 5'6", 147-pound African-American man, Daniel, asked the major what the problem was. The major told the suspect there was no problem and he could go back to his steps. The major reported that Daniel walked in front of the major's vehicle acting in an agitated state, wearing and adjusting some type of athletic gloves and taking his shoes off. What the hell is that? An older African-American man was instructing the young man to stop acting like this. Daniel began yelling at this older male in a threatening manner and challenging him. The major called for backup, withdrew his taser, and ordered Daniel to sit on the curb. A lieutenant arrived as backup. The major reportedly told the lieutenant that the young man was warned to desist, but to no avail, and is ready to fight. He needs to be arrested before he hurts someone. The investigating sergeant reported that the subject moved to one side of the street and sat on the curb. The major informed the lieutenant that Daniel was the aggressor and he continued to be a threat. There is no indication in the report that Daniel stood up from his seated position on the curb. Nevertheless, the lieutenant immediately pushed Daniel to the ground with a left foot kick to the chest. Daniel had committed no crime, was seated on a curb, and obeying officers' commands at the time the lieutenant unnecessarily and unreasonably kicked him in the chest. This incident, involving a lieutenant and a major, was investigated by a lower-ranked sergeant, undermining the credibility of the investigation. The major, who was involved in the incident, ultimately approved the sergeant's investigation, though the major lacked the independence to objectively determine whether the force used was appropriate. Officers also use heavy-handed tactics when civilians simply refuse to obey their commands and escalate encounters by resorting to force too quickly, including against individuals who are not being arrested for any crime, with mental health disabilities or in crisis. We determined that approximately 20% of use of force files BPD provided involved individuals with mental health disabilities or in crisis. And one of many such incidents we reviewed, in 2013, 3 officers and 1 sergeant responded to a call to transport an individual to a hospital for mental health evaluation. According to their report, the officers arrived at the back of a house and found a woman, Ashley, the subject of the petition, sitting on the ground with a clenched hand. Ashley reportedly had a small build and was yelling, "Don't shoot me." One officer asked her to empty her pockets and she refused, stating, "You have to shoot me first. I am not giving it up." There is no indication that the officers attempted to verbally persuade Ashley in any way to open her hand or calm down. Rather, the officers physically attempted to force her hands open. Ashley resisted the officers' physical attempts and began to kick and swing at them. According to the report, one officer used a taser in drive stun mode to try to calm her down. In case you guys don't know what drive stun mode is, that's where they actually place the stun gun on your body. Okay, it's set at the highest setting. They hit the button and it delivers a much more powerful stun to you, i.e. electricity entering your body. And I mean, I haven't been drive stunned, but I have been stunned with a stun gun, and I am here to tell you that is no fun whatsoever. All right, I continue. Because drive stunning an individual causes great pain, yeah, that's true, it did not calm her. The technique also carries a heightened risk of serious harm or injury when used on individuals with mental health disabilities or in crisis. It also carries a heightened risk of serious harm when they use it on a person who has a heart condition, i.e. me. Ashley continued to resist. In response, the officer drive stunned her 2 more times with similar results. The officers were eventually able to physically pry open Ashley's hands, which held 2 vials, the contents of which emptied onto the ground. Ashley was transported to the hospital for a psychiatric evaluation. Use of the taser in drive stun mode 3 times against a woman experiencing crisis who was unarmed posed no serious threat to the officers or others and was not being arrested for any crime was unnecessary and unreasonable. Problematically, it appears the only investigation of this incident was conducted by the sergeant who was at the scene. A sergeant who participated in the incident lacks the necessary objectivity and independence to fairly assess whether officers on the scene acted appropriately. Having an involved sergeant investigate the force undermines the integrity of the investigation. Aggressive and violent police interactions, such as those described above, have left some Baltimore residents with the belief that encounters with BPD officers will result in their being subjected to unnecessary force. Community members told us in interviews that even when they believe they have done nothing wrong, they flee from interactions with officers, believing that it is better to run at the sight of an officer rather than take the risk that an interaction with the officer will result in unnecessary and excessive force being used against them. Indeed, officers' unnecessary and unreasonable force during arrests for highly discretionary charges such as loitering, disorderly conduct, resisting or failure to obey an officer's commands confirm these community members' fears. The fault for officers' systematic use for these heavy-handed tactics lies with BPD as an agency. Through training used for many years, some of which is still going on, BPD teaches officers to use aggressive tactics. We reviewed a number of training materials such as BPD's academy-level training on use of force, defensive tactics, and BPD's in-service training on characteristics of an armed person. We also observed in person BPD's training on foot patrols and interaction with people with mental illness. Through its defense tactics training, for example, BPD instructs officers to point their firearm at individuals when they need to control a scene. In the cases we reviewed and in media reports, we saw this troubling tactic in operation. BPD groups this tactic on par with command presence verbal commands, and using a firm grip. Pointing a gun at an individual for general control is an inappropriate use of a firearm and is a threat of deadly force where the underlying offense, if any, does not justify deadly force being used. Holland v. Harrington, 2001, explains that an officer pointing of a firearm involves the immediate threat of deadly force and thus should be predicated on at least a perceived risk of injury or danger to the officers or others based upon what the officers know at the time. Pointing firearms directly at individuals is also dangerous because it can lead to accidental discharges, limit officers' ability to use other more appropriate force when one hand is occupied with holding a firearm, and lead to unnecessary use of deadly force. During our interview, we saw instances in which officers drew and pointed their firearms at individuals when the use of deadly force did not appear to be justified, including an incident that resulted in an accidental discharge that fortunately did not strike anyone. In part through aggressive tactics such as these, BPD's training fuel and us versus them mentality we saw some officers display towards community members, alienating the civilians they are meant to serve. Moreover, the department has failed to equip officers with sufficient de-escalation skills and tactics. The department had no comprehensive training on de-escalation techniques until 2015, when it added de-escalation training to the Academy's use of force curriculum for new recruits. We commend the department for its efforts, blah, 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 blah. Number 2, BPD uses unreasonable force against individuals with a mental health disability and those in crisis and fails to make reasonable modifications when interacting with individuals with mental health disabilities. BPD officers routinely use unreasonable force against individuals with mental health disabilities or those experiencing a crisis in violation of the Fourth Amendment. Additionally, by routinely using unreasonable force against individuals with mental health disabilities, BPD officers repeatedly failed to make reasonable modifications necessary to avoid discrimination in violation of Title II of the Americans with Disabilities Act of 1990. Since 2004, BPD has provided some specialized training to its new officers on how to interact with individuals with disabilities and those in crisis, but this training has not been provided to all officers. Moreover, the department does not have a protocol requiring that a person with this training be dispatched to a crisis call. The result is that BPD officers frequently fail to de-escalate encounters with unarmed individuals with mental health disabilities and those in crisis. Indeed, their tactics often escalate these encounters. Instead of requesting an officer trained in handling crisis events or a mobile crisis team made up of trained mental health professionals, officers handcuff and detain people with mental health disabilities and those in crisis and resort too quickly to force without understanding or accounting for the person's disability or crisis. For example, BPD officers often are called to the scene to escort individuals likely to have disabilities to a hospital for a mental health evaluation, referred to as an emergency petition under Maryland law, and possible civil commitment. Frequently, these individuals have committed no crime and present no significant threat to officers or other members of the public. Where a seizure's sole justification is preventing harm to the subject of the seizure, the government has little interest in using force to effect that seizure. Rather, using force likely to harm the subject is manifestly contrary to the government's interest in initiating that seizure. In the course of engaging with these individuals, usually to transport them for medical treatment, BPD officers resort to using unreasonable force if individuals fail to comply with their commands. Under the Fourth Amendment, officers who encounter an unarmed and minimally threatening individual who is exhibiting conspicuous signs that he is mentally unstable must de-escalate the situation and adjust the application of force downward. Similarly, the ADA, which applies to BPD services, programs, and activities, including on-the-street encounters, arrests, and transportation to a hospital for mental evaluation, requires BPD to make reasonable modifications in policies, practices, or procedures when the modifications are necessary to avoid discrimination on the basis of disability. BPD's obligations apply when officers respond to a scene where they know or reasonably should know that an individual has a mental health disability. For example, BPD has knowledge of an individual's disability when BPD is called for an emergency petition when a mother calls 911 and says her son has schizophrenia and is not eating, or when a person is exhibiting apparent signs of mental illness. Training BPD officers on how to interact with individuals with mental health disabilities is a reasonable modification to policies, practices, and procedures to afford people with mental health disabilities the equal opportunity for a police intervention that is free from unreasonable force. Sorry about that. Estate of Saylor versus Regal Cinemas, 2014, holding that the failure to provide appropriate training for officers to interact with individuals with developmental disabilities, which resulted in the death of a 26-year-old man with Down syndrome after officers attempted to force him to leave a movie theater, properly stated a claim under Title II of the ADA. Among other things, such training should result in officers employing appropriate de-escalation techniques or involving mental health professionals or specially trained crisis intervention officers. Rather than employing such de-escalation tactics, we found that BPD officers often resort too quickly to using force against individuals with mental health disabilities or in crisis. We found that on many occasions, the officers' unreasonable use of force involved use of tasers in drive-stun mode. As the Fourth Circuit has recognized, deploying a taser is a serious use of force. The weapon is designed to cause excruciating pain, and application can burn a subject's flesh. The court noted that using drive-stun mode to achieve pain compliance may have limited effectiveness, and when used repeatedly may even exacerbate the situation. Tasers generally have two modes. In dart mode, a taser shoots probes into a subject and overrides the central nervous system. The drive-stun mode, on the other hand, does not cause an override of the victim's central nervous system. That mode is used as a pain compliance tool, and cops love using that. It's used as a pain compliance tool with limited threat reduction. Even Taser International, the company that manufactures tasers, has cautioned against using the drive-stun mode on emotionally disturbed persons or others who may not respond to pain due to a mind-body disconnect. Nevertheless, BPD officers have repeatedly used drive-stuns while responding to people with mental health disabilities and those in crisis, causing unnecessary pain and suffering without any noticeable benefit. In fact, these uses often, if anything, exacerbate the situation. In a 2011 incident, we reviewed several officers responding to a call about a domestic disturbance, at which point they were flagged down by Michael, standing outside without shoes in January weather, smelling of alcohol. His wife, present at the scene, informed officers that she had not been assaulted, but that her husband was intoxicated and that she was packing things to leave for the night. Michael yelled profanities and stated that he wanted to die. Instead of using de-escalation techniques, calling for help from an officer trained in crisis intervention techniques or a mental health professional, or working to connect Michael with appropriate treatment services, the officers attempted to physically force Michael into handcuffs, and when he resisted, drive-stunned him with a taser 5 to 6 times. One officer specifically noted in his report that the taser seemed to have a minimal effect upon Michael, possibly due to the level of alcohol intoxication and mentally disturbed state. After handcuffing him, the officers took Michael to the hospital for stabilization. He was never charged with a crime. The force used by the officers was unreasonable because he had not committed a crime and did not appear to pose a threat to officers or his wife. It was also ineffective in rendering Michael compliant and caused unneeded suffering without any appreciable benefit. All right, I'm at 1915, so I'm going to stop this video and start up the next one.